transaction. November 2023. We are going to look at the first 3 questions, and then we are going to look at the other 3 questions on Wednesday. So, commercial transaction is one of the most difficult subject in Kenya School of Law, and ones need to read widely to be able to understand this topic. There are several topics here, and any topic can be tested, whether it's companies, whether it's solvency, whether it's a financial payment system, whether it's taxation, whether it's partnership. Each and every all the topics there can be tested. So, and of course, companies and insolvency are very wide and deep. So someone needs to read deep widely. And the only secret to passing this exam is reading widely. There is no shortcut for someone to be able to pass these exams. You must be able, unless you have the leakage. That's another thing. But if you want to pass this exam, you must read widely. And the purposes of this class, in an exam, at least half of the question will be repeated directly or indirectly. At least 30 out of 60 will be directly or indirectly from past papers. So the purposes of looking at these past papers is to help you someone to prepare for the exams. And on the website, I've researched 3 papers. 2008 to 2019 combined 500, June 2021 500, November 2021 100, April 2022 100. Then there are videos we did ahead of last year's exam, November, October 2022 and April 2022. October 2022 and March 2023. And those are uploaded there. So we are November 2023, then we are going to go to April 2024, and we shall be done. So if someone wants to pass these exams, there is no shortcut. You must subscribe to those papers. You see the answers, and listen to the videos. So I want to share now the paper. I'm still working on the papers on the website, the question papers. They keep mixing up. There is an issue on the website which we are trying to solve with the developer. But eventually, if you want to, all past papers will be there without any problem. So you don't need to go anywhere else to look for past paper. Of course, everything is read only. You can't download. Yeah. So I'm going to read question 1. Question 1 is compulsory. And also, let me say something on a strategy in doing the exams. The first 15 minutes, when you are given a question paper, you read the questions to eliminate one question. To eliminate one, because it's only one question that you not do. So you read all the questions to understand them, to see this one I can do, this one I can do, this one I can do. So you eliminate one. So you eliminate one, the most difficult question. And then if when you are doing, you start with the most easiest. Going, yeah, you arrange because it gives you confidence and also gives the confidence of the marker. So that is, and it's captured in my document called Do It by Exams. And of course, compulsory question, you must do it. If you don't do, according to CLE rules, you get 0. So that is the strategy. And each and every question you assign time. So you assign each and every question time. If time ends before you finish that question, go to the next. Go to the next, then the last 15 minutes you can come and complete. So you don't end up doing three questions and don't do it two because you spend too much time on one question. So each question is important because they hold the same marks. Even if you know one question more than the other, still you need to balance. Of course, converse is the most the question one compulsory question is the most important. Yeah, because you must do it. Yeah. So I'm going to read the question now. Having done that introduction, Keno Sugar Limited is a living private company involved in importation of milling of sugar. It is located in western side of the country and has enjoyed many years, of course, relationship with the government of the day. The company has done very well owing to the corruption and mismanagement of its competitors, where the government is majority shareholding, leading to a closure of some of them. Keno Sugar Limited is currently the dominant market player and controls up to 40% of sugar market share. The fortune of Keno Sugar Limited started to dwindle when the new administration got elected following the 2022 general elections. The current government has taken a hostile stance on the company, including in particular accusing Keno Sugar Limited of being responsible for cartels in the sugar industry and the reason behind the closure of its competitors. It has vowed to dismantle the cartels and return the sugar factories back to the sugar farmers in rural areas and provide jobs for the youth as part of campaign pledges. Kenya Sugar Limited is concerned that they may soon be starting at insolvency if present attacks by the government continues and the revival of its competition is achieved. Revival of its competitors is achieved. So that here there was a mistake. As leading insolvency practitioner in Kenya, write a detailed legal brief enumerating the circumstances under which the company may be liquidated voluntarily to avoid insolvency. So, what do you think, Kate? Interpret the question. You can hear me?
Can you hear me? Can you hear me, Mwalimu?
Yes, I can hear you very well.
Okay. I think there's an issue with my headset.
Okay.
Sorry, just some minutes.
Okay.
So I think my interpretation of this is we are talking about insolvency. And
Mm-hmm. 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 Can you hear me? You can remove the headphone and speak to the laptop directly, yeah?
hear me, Mwalimu?
I can hear you. I'm saying
Okay. Yes.
you remove
So
the headphone and speak directly to your laptop, eh?
yes, I've already removed.
Yeah.
I've already removed. I'm using a different gadget. So so I think I would say that we are talking about insolvency, and they want to look at the various ways within which Sugar can sort of claim insolvency over and above other sources. So I think it's just guidance on what can trigger insolvency. Can I make an attempt?
Yeah, make an attempt.
Okay, so the first one that is coming out from the question, because it might be that they want to proactively be insolvent, is that the shareholders can have can pass a resolution, a special resolution to commence insolvency proceedings, which could lead to liquidation. Sorry, indicating that they want to liquidate the company. The second one is creditors can also make an application for insolvency. And these are creditors referring here to lenders. Then we have suppliers. Suppliers can also apply for insolvency. So those are the three that are top of my head. Now, the details therein would then be the processes with which each of the various parties would need to undertake to commence the liquidation process. Yes.
That is a very good attempt. Yeah, so this question is very direct. If you look, can you see the question?
Yes, I can, Mwalimu.
So the question is, read a detailed brief, the circumstances under which the company may be liquidated to avoid insolvency. Voluntarily. So the keyword here is voluntarily. Unaona? So anytime the creditors come into because the company has been unable to pay its debts, that one is called involuntary, yeah? Which has been tested in the past. So, but where the circumstances are company voluntarily, the shareholders and the directors want to do it voluntarily. So now this is what the question. So the keyword here is voluntarily. So your answer part one, your first where you are saying shareholders voluntary. So that was your point one was correct. But where you now introduce a court or creditors, now you talk about involuntary insolvency or liquidation. So it's circumstances. So circumstances, and this question is 5 marks. So the answer is found in section 397(1) of the Insolvency Act. I said before you joined the introduction that companies and the insolvency, someone must be able to read the company's and the Insolvency Companies Act and its regulations, and Insolvencies Act and its regulation. Because companies question and insolvency, you not get less than 20 marks in a question. A third of the question that will come from any past papers involve this, and is the most huge, the most huge topics in commercial transaction. So someone needs to read, understand, make small notes, even if it is matrix. Yeah.
So, Mwalimu, just a question.
Yes.
When you look at section 403, they take creditors as voluntary liquidation. How then would we address it?
Sorry?
Section 403.
Oh, 403. Let me look at 403. Effect of companies' insolvency.
Yes.
This
so
is Insolvency Act.
Yes. So voluntary, they indicate it to be more than one, the members. It does indicate creditors.
You are reading which section?
So let me just open it up.
And always have the latest. In an exam, go to Kenya Law Report website and download.
Yes.
Yeah, the latest. They keep amending these things.
So if you look at section 408, it says creditors voluntary liquidation. So does that mean that, like, and then 399 says members voluntary liquidation. So for this question, would you mention just members or would you include creditors?
I'm at section.
So section 408, yeah, it refers to creditors voluntary liquidation. So when it speaks to it being voluntary, who's, like, what's the pivot? Is it voluntary by the members or voluntary by the class of claimants? Because the Act has both members and creditors as voluntary.
So to answer that question, let's start at 405.
Yes.
Expect as provided under 2. The division applies to relation to creditors voluntary liquidation. Section 4.6.4.7 does not apply if under section a member's voluntary has becomes a creditor's voluntary liquidation. So a company that is in course of liquidation shall so section 4.6 and 4.7 does not apply under 4.7 members voluntary liquidation.
So it says if under section 404, and 404 is conversion to creditors voluntary liquidation. So this part has effect if the director's declaration under section 398 has not been made, the creditors meeting and the company meeting at which it was resolved that the company be liquidated voluntarily were the meetings referred to in section 406, and 406 is the creditors, and the liquidation becomes creditors voluntary liquidation. So 398, 398, assume is the one for directors of the company. And I see why perhaps this is, because directors cannot don't have a form of liquidation, but they can make a declaration of solvency, which I think when they do, the creditors can pick it up and make it creditors voluntary liquidation, because only members, the shareholders, can perhaps have an action. That's my interpretation.
Haya.
Via CPMs.
So when going back to the question,
Yes.
as leading for service, give a detailed M&A circumstances under which a company may be liquidated voluntarily to avoid insolvency. So when by the entry of the creditors, is it voluntary or become involuntary?
Mwalimu, we were told that our opinions with regards to CLE don't matter. It's what the law states. So in this regard, your assessment is 100% correct. But what the Act says is that they are both forms of voluntary liquidation. How then would we approach it?
Meetings of creditors voluntary liquidation. So we can say, you can start by this section. If I was answering this question, I'll stick with sections 393. Can you look at 393?
Yes, 393. A company may be liquidated voluntarily when the period, if any, fixed for the duration of the company by the articles expire, or the event, if any, occurs on the occurrence of which the articles provide that the company is to be dissolved, and the company in general meeting has passed a resolution providing for its voluntary liquidation, or if the company resolves by special resolution that it be liquidated voluntarily. So, but then it goes further to say, before passing a resolution for voluntary liquidation, the company shall give notice of the resolution to the holder of any qualifying floating charge in respect of the company property. So this is just the process.
So okay, you can, if I when I was preparing for this, I had not thought about creditors voluntary liquidation. But because it's talking about, because the question is talking about if the president attacks by government, as leading insolvency in Kenya, read a detailed brief and made the circumstances under which a company may be liquidated to avoid insolvency. So, yeah, you have introduced Nini I had not thought about. So, to answer this question, you can talk about that 393 one.
Yes.
Circumstances where the period if any is fixed for a duration of the company by articles expires, that is one. Or event or the events of any occurs on the occurrence of articles provided the company is dissolved and the company in the general meeting has passed a resolution provided for voluntary liquidation, that is two. Or if a company by special resolution is to be liquidated voluntarily. So there are like three key points.
Yes. And actually how you have answered it, it does make sense. It doesn't make reference to the types of voluntary liquidation. It refers to circumstances for when the voluntary liquidation to avoid. But when it says to avoid insolvency, when it has been, it's for a fixed time, it is not insolvent.
Yeah.
Then do we say when the duration has ended is to avoid insolvency, or perhaps when you think about it, actually could lead to insolvency, because then what would happen is someone can invalidate its continued operation by saying any business they undertake beyond a certain period in time is invalid, and it can force, someone can go to court to force it to shut down or to be liquidated, but not
And
necessarily to avoid insolvency.
yes.
Okay.
Yeah. So me,
Mm-hmm.
I'll stick with 393 1A.
Okay. Yes.
393 1 at A and B,
Yes.
but there is no harm of circumstances. There is no harm also of introducing creditors voluntary liquidation,
Mm-hmm.
but it needs more. It needs more research.
Yeah, it does. And if, especially you look at the clauses around 408, it doesn't speak to circumstances, but 393 straight up speaks to circumstances.
Yes.
So it could be that for this one, regardless of the confusion, if we're looking at what the Act says, it's 393 that we should apply. Yeah, so
Because you can be asked types of voluntary liquidation.
yes.
Now you can talk about members voluntary liquidation, then creditors voluntary in fact, division 3 is members voluntary liquidation. Division 4 is creditors voluntary liquidation. So what is division 3? Division 3 is members liquidated. It starts where?
Division 3 is members. Division 2
Division
speaks
1
to
is introduction.
Yes, division 1 is, let me see.
Introduction.
Yes, division 1 is introduction.
Division 2 is?
Division 2 is
voluntary.
liquidation, is where 393 begins, and then division 3 is members voluntary liquidation. Division 4 is creditors voluntary liquidation.
So there is a difference. You see, as lawyers,
yes,
lawyers read strictly. So there's when you are told about types of voluntary liquidation, and it can come,
yes,
you talk members and creditors,
yes,
but if it is circumstances,
yes,
you stick with 393. So that is a correct interpretation.
yes.
Yeah. So voluntary liquidation question have been asked in the past. If you've interacted with the question and answers. Yeah, but the thing here, which I think has not come and it might come, is I did not see anything to do with a process of this whole process of members voluntary liquidation.
Okay.
You see, you can be asked the process, which will be, of course, will be more marks than this.
Yes.
But the process of involuntary liquidation by creditors, has been asked. Unaona? So prepare for that.
Okay.
So question B, the register of companies has recently run to Kino Sugar Limited in relation to these beneficial owners, following claims that it was responsible for capitalism in the sugar industry. The company has come to your offices seeking to know who is the beneficial owner and what is the condition should be met for natural person to qualify as beneficial of owner of company and the company's beneficial ownership information regulation 2025 marks. So interpret the question. Hope you can see it.
Yes, I can. I think here what they're trying to do is what's the threshold of the declaration of beneficial owners in a company? And that is usually guided by regulation. Yes, so beneficial ownership refers to the last natural person that is behind a company. So it sort of lifts the veil for the ownership for purposes of disclosure. Yes.
Yeah, that is a beneficial owner is the ultimate person, the natural person who owns or control a legal person, which is a company. Yeah?
Yes.
So the question is asking.
Sorry, which is no, it's usually a person, an individual, to the extent possible.
Yes.
Okay.
Beneficial owner. So then the question is asking you also, who is a beneficial owner? What are the conditions should be met for natural person to qualify as a beneficial owner? So that one, if you introduce now here, this is where the many marks will come from. Yeah. What are the conditions should be?
So there are several things that they look at. They look at shareholding in terms of issued shares. They look at voting rights. They look at who holds or who exercises significant influence in terms of their ability to appoint directors or remove directors. So anyone who meets that threshold and they in that threshold for shareholding and voting rights are at 10% and above, then they do meet the threshold for beneficial ownership and a threshold now for disclosure to the natural person. Yeah.
Yes, so that is the correct answer. It is found in section in regulation 3.2.
Yes.
Regulation 3.2 of these regulations, the beneficial ownership. So the threshold is something someone needs to, of course, you are right. 10% of issued shares in the company, either directly and indirectly. 10% of voting rights in the company is directly and indirectly, or a right directly or indirectly to remove a majority of members of the board of directors, or exercise significant influence or significant control directly or indirectly over the company. So here there are 4 points, and if you combine with the definition of beneficial owner, I think you get your 5 marks.
Yes.
Yeah, this question on beneficial ownership was asked in March. Yeah, it was asked in another way. It was asking on the process of discussing beneficial ownership. The need on the process of discussing beneficial ownership. So is an area that is coming a lot.
Okay. I will
So
read
as
up on it.
predicted, Kino Sugar Limited is currently currently experiencing cash flow problem as a result of government attacks and has defaulted on its obligation to pay its creditors. Kino Sugar Limited has approached a local bank and seeks to use its tracts as security. Therefore, a security agreement containing the most important elements. So I remember I'm happy. I predicted that I told the last year people that security
Mm.
rights drafting a security rights agreement has not come, and it
Mm.
came. So my prediction was correct.
Yes.
So I want to give you an opportunity to draft.
Okay.
So draft,
Um,
scan and
um,
send.
or can I type and share on screen?
And I'm saying
Mm-hmm.
later before Wednesday we are going to start with this question.
Okay.
You draft, you indicate the time you have taken, you do a good handwriting, you scan PDF and send.
Okay, I'll do that.
Yes, and commercial agreement topic is it's a topic, you know that.
Yes.
So you can be told to draft anything in commercial agreement.
Yes.
Yeah, you last in March they were told about rate of guaranteed. There is security agreement. You can be told to draft a partnership agreement. Many things, anything, provided is commercial.
Okay.
So it's good to be prepared. So as its fortune continue to dwindle, Kino Sugar Limited has no option but to sell some of its vast land at 250 shillings. Uh, it had bought the land 10 years ago at 100 million shillings. The legal fees and other incidental costs related to transaction stand at 17 million. The company has erected a fence and some buildings on the land amounting to 5 million shillings. At time of purchasing the land, it has also paid its lawyers 3 million in legal fees. Calculate the capital gains tax payable. So, even this one, I want you to see your answer.
Okay.
I want you to,
So
you
I
do like
don't
an exam.
have this paper. I don't have this
I-
paper.
I'm going to send it to you after the class.
Okay, thank you.
So, I want to see your calculation, your answer, how you write in an exam.
All right.
And see if you can get 5 marks. So we are going to start with the two. One C and D on Wednesday.
Okay.
So question 2. And you see the good thing with capital gain tax is also in conveyancing.
Yes.
Yeah. So you be striking two doves with one stone. So question 2.
Mm.
Joseph and his wife Amanda have lived in the United States of America for many years and plan on relocating back in home in course of coming years. While in the United States, they did well for themselves and set aside adequate funds on which to retire. Joseph grew up in the dry part of the city and wishes to give back to the society by setting up a children's home and educational center on the piece of land Amanda have identified as ideal for that purpose. Other than themselves, venture and five of them have each pledged $50,000. Joseph and Amanda has sum of 9 million set apart for that task. The couple are God-fearing and are very keen on money being put in proper use. As such, they intend to register a vehicle to run the children's home and the school. Further, they are sure that their friends who has pledged support for that cause will be more comfortable for if their contribution are applied by a separate separate entity from the couple. They also wish that the institution they establish is able to attract further funding for expansion. Since they have saved enough for their retirement, they do not wish to receive any income from the entity they set up. Joseph and Amanda approach you and ask you to advise on the nature and the most ideal entity to establish as well as procedure requirements for registration. Advise Joseph and Amanda now A and the ideal entity that will be best vehicle for charitable purposes and explain for them the reason of your choice. So what do you think?
I think here we are referring to a charitable trust. There is a provision for creation of charitable trusts. So that's the approach I would recommend that they take. And so ideal reasons. So there are several reasons. One, the tax, that tax will not be applicable. Then the second thing is the receipt of grants become easy. And especially with this whole thing of money coming in for a particular reason, it needs to come in through a process that it will also not be taxed. So they're able to receive grants, which means that they're able to have a higher percentage of usage of that money. Then the third thing is ownership of property. So if you register a trust, you'll be able to have that company own its own property under its own name, as opposed to having Joseph and Amanda as the ownership, and therein create a separation of interest. The fourth one is the ability to run and operate bank accounts. So when you register it as a charitable trust, even a bank can identifies it as a company that is separate of its trustees, and they're able to run and operate the account by that name. Then the other benefit for that is now the ability to have transparency in the operation of the institution.
Yes, that is correct. That is one answer you can give. This is a question that has two answers. What do you think about company limited by guaranteed?
The tax element is unclear. I think they'll still be liable for tax. And since it is for charitable purposes, and the principal role of tax is where a profit is derived that then tax is payable. That's why I wouldn't look for company by guarantee.
Does company limited by guaranteed pay tax? I don't think so.
So a company limited by guarantee, by what I read, is by all intents and purposes a limited company that can undertake unlimited forms of business.
Okay.
Which by that it means that it would also be liable to pay taxes. Now, if my understanding is wrong, then I should be considering setting up all the companies in future as guarantee. I would imagine it would be such a huge loophole for the tax authority to exempt a company limited by guarantee from tax.
They are saying here that some of them are exempted, non-profiting organization. So
you
it's
could
what
be
you are
an
saying.
NGO.
That you apply for exemption.
You register it by guarantee and then, okay.
Yes.
Wouldn't that create a restriction of perhaps future grants that may come that may be beyond the first guarantee amount? And if every time they have to update it, wouldn't it be much more arduous?
That one I cannot nini. Okay, let me ask you another question.
Yes.
Did you read about charitable trust in commercial?
Not specifically. I don't remember specifically, but I did miss some classes, so I may not be stating fact.
Okay.
But I think charitable trust is from previous interaction, from that basis that I'm answering. Yeah.
So trust deed, drafting a trust deed is one of the commercial agreements.
Yes.
I'm looking at your course outline. So with necessary modification, I think this answer, this question has two answers. It's one of the questions that has two answers.
Okay.
It is, the answer is because you see, trust, you see, you answer a question according to the course outline.
Yes.
Not to your general knowledge, and it's that subject you are dealing with, commercial. Now, a commercial question, you answer in commercial. Conveyancing, you have that in mind.
Okay.
So this is the one, I will say this is one of the questions that has two answers. I will go with what you are saying, charitable trust. Because
But if you are to go with a guarantee, what would be the benefits for the choice or the reasons for your choice?
Explain the reason of your choice.
Yeah, what would be the reasons why one would pick by guarantee?
Because I will say, first of all, there is a separate legal entity. When it is registered, it has separate legal entity. And in case of insolvency, the directors pay the debts or the loans to amount to which they have guaranteed. So that is one of the advantage. Of course, they don't pay. Okay, they don't, because it's charitable. Also, they are going to apply for tax exemption. So yeah. So the ability of members is limited to the amount they agree to contribute to company asset if it is liquidated. Unaona? Yeah. So that is what I will talk about. So because the word here they are talking about separate legal entity. So because charitable trust is in fact charitable trust is more probate. You know that? It's more probate. You know that?
But they have made provisions for creating it differently. And the final step that you do to create it as a separate entity is by registering with the Ministry of Lands for it to be an incorporation.
Mhm.
Yeah.
So this your answer is I would say this is a question that has two answers. It can
Yeah.
be a
Okay.
trust, it can be a trust or company limited by guarantee. So let's go to the next. Advise Joseph Amanda the general process of setting up the entity in Kenya. So what is the process?
So you have to go through the picking up of names, you get the names. You draft a trust deed, you provide the relevant documentation for the trustees. Then using those documents, you make an application to the business registration services. After that application has been done, you will get a confirmation of its registration and the stamping of the trust deed. And based on that information, you can commence business. However, to make it an incorporated entity, you apply to the Ministry of Lands, to the registrar, to apply for it to be handled as an incorporation or as an entity incorporated, upon which then that is granted and you're issued with the relevant certificate for incorporation. Yeah.
Good. So let me also now talk about what I had prepared on company limited on guaranteed.
Okay, yes.
So they have of course this is the same as registration of a private company and company limited guarantee. These are things I have done practically for a client. So you go to eCitizen, you do a name reservation in order of the precedence of the name you want them to take. So they take the first name the way you want the ranking.
Yes.
Then fill in the details which are there, like the directors details, company's detail, physical address, and all those things. So eCitizen will generate something called a CR1. Details of the first directors, and CR8, notice of residential address. Yeah, you are supposed to sign them and scan and return. Then there's something called statement of guarantee. You sign and upload. Then you pay 13,100. So the BRS officials who are lawyers, they are going to review the documents. And they usually tell you amend here and amend there. So after they approve, they give you a certificate. And a certificate must be written company limited by guaranteed. It is in the act. The certificate must read company limited by guaranteed. So that is the purpose of company limited by guaranteed. You have talked about incorporation of a trust. Private company has been tested. The only area that has not been tested, even registration of a foreign company has been tested. The only area that has not been tested in this around this area is public companies. Nothing. So that is my prediction. Go and look at public companies.
Okay.
Yeah, look. Nothing has come on public companies, whether process, whether even theory question. Nothing has come on public companies.
Okay.
Yeah, so these are this was one of the questions that usually have two answers. I would say that. Yeah, and civil litigation also drafting. Some of these drafting usually have two answers. You can even in criminal civil litigation, a question may ask you, for example, DPP charged you what the defective charge sheet. You want to approach court to quash the charge sheet. So that there you can draft a judicial review application or a petition. Both can work, eh?
Okay.
Yeah. So this kind of drafting usually have two answers. So question 3, the last question of the day. A few years ago, Drake and Rebecca were soon as advocate of High Court of Kenya. Having decided to go into business together, their chosen vehicle was a limited liability partnership, LLP, pursuant to LLP Act 2011. In short time, Drake and Rebecca LLP grew into a thriving practice, and partners were able to accumulate a liquid asset base of 5 million, clear of liability. Several partnership meetings were held in which Drake indicated that he was interested in investing funds towards opening another branch of the partnership. With Rebecca felt that his time was right for firms to invest in real estate market. While discussions were ongoing, Rebecca, without Drake's approval, entered into a contract with one of the regular clients, Hodari Real Estate, to purchase offices of plan in amount of Kenya 5 million, believing that she could flip the offices and suit and sell it to that party for even more money without Drake's knowledge. The office suits having been completed, Hodari Real Estate is demanding payment, but Drake insists that there is no binding agreement between the parties. So discuss whether or not Rebecca had the power to act as agent of the firm in the real estate contract, and if the firm is so bound. Interpret the question.
So I think these are parties in a limited liability partnership. You have Drake and Rebecca as partners in there. So the question is around the decisioning process. Yeah, like how are decisions made in an LLP in a nutshell. Yes, because the rest of the information is a decision was made and a contract entered into. Yeah.
So what do you think is the answer?
So the first question is discuss whether or not Rebecca had the power to act as an agent of the firm in the real estate contract, and if the firm is bound. So as to whether Rebecca had the power, that information will be in the partnership deed that would determine the process of decision making. And if just a little bit, several partnership meetings were held in which Drake indicated that he was interested in investing the funds towards opening another branch of the partnership, while Rebecca felt that they wanted to get into real estate. So what appears is that they've had several meetings and they never came to a meeting of minds. But the only difference is that Rebecca proceeded to enter into a contract based on her position. So in this regard,
Mhm.
Rebecca had no power to act as an agent of the firm.
Mhm.
Now, the actions, another party, a partner is bound by the actions of a partner if
Mm.
the actions that the partner has taken are in accordance to what the partnership did, requires, or follows. So in that
Mhm.
regard, Drake would be correct in saying that there is no binding agreement and binding the firm. However, if I was Hodari, then I would now pursue Rebecca as an individual.
Yes. Good. That is the answer. This is a question that is usually repeated many times. Whether a partner can be able to bind a partnership where there is no express authority to do something.
Yes.
So you start with section 11(1) of the partner of the LLP. You say that a partner of the limited liability partnership is an agent of the limited liability partners. However, section 11(2), a limited liability partnership is not bound by anything done by partner in dealing with a person if a partner has in fact no authority to act, or the person who knows that the person has no authority, or does not know or believe that person to be partner of the limited liability partnership. So all these scenario has been brought. So then after saying that, you say that the partnership is not bound and that people can pursue Rebecca in the individual capacity, and you get your 4 marks, as you have said. So after several engagement between Hodari Real Estate and Drake and Rebecca, the partners agree that a penalty of Kenya shillings 1 million will be paid by the firm to Hodari Real Estate as damages for failing to take up the unit. Drake also reveals to you that there is no written LLP agreement between him and Rebecca, and there is only did he put up a larger shares of state up capital, but he's also the sole signatory of firm's account. Drake is in the opinion that by dint of Rebecca being involved in day-to-day decision of the firm, up to the including participating in the investment, that she's personally liable for her share of penalty. And Drake now wishes to expel Rebecca for partnership and retain the bulk of the partnership capital and assets. So evaluate the merits of Drake's position with reference to relevant provisions in law. So interpret the question.
Evaluate the merit of Drake's position with reference to the relevant provisions in law. Evaluate the merit of Drake's position with reference to.
So this question, first of all, despite despite what Rebecca did, this company had a meeting, both of them.
Yes.
Then they agreed that the penalty the company is going to charge the partnership a penalty of 1 million for not taking the unit. So there's no written LLP agreement between the partners, Drake and Rebecca. Then so Drake says that he put a lot of money in the partnership. And it's also the sole signatory. So Rebecca being the person who was involved in day-to-day decision of the farm up to the including participating in the investment, is you'd be personally liable for the share of the penalty, her share of the person. She's personally, so even if they say the partnership is going to pay 1 million, she, of course, it's like 500,000 will be paid by the partnership, then 500 will be paid by Rebecca because he was involved in day-to-day running of the partnership. And Drake also want to expel Rebecca and retain the partnership capital and assets because he says he's the one who contributed a lot. So there are many things to deal with here.
Yeah.
That's why they give 6 marks.
So evaluate the merit of Drake's position. So first thing, an LLP cannot be inferred. In my view, it cannot be inferred. It has to be in writing. It has to be registered. There is, since there is nothing written, his position, he cannot take the position that by the fact that Rebecca is involved in the day-to-day, that she has to be responsible as the farm based on the nuances of partnership. Then it is said that he put up a larger share, which means there's what Rebecca put in, which may not be as big as what he put in. So I think for this one, I'm a bit confused as to how best to answer it. The only view I have is that Drake should not have accepted to pay any penalties because he now has liability as the farm, whereas the position of him walking away and saying that it's not binding would have meant that Rebecca takes 100%. But I take your guidance. I'm lost on how best to answer this one.
So I want you to, you have your LLP.
Yes, I have it in front of me.
Sawa sawa. You know, it wants you to read, and you read very well this LLP and interpret it. Interpret the question.
Yes.
So let's start with section 12.
Okay.
So if you look at your section 12, what does it say? 12.1.
So how the relationship of partners is to be governed, except as otherwise provided by this act, the mutual rights and duties of the partners of an LLP and the mutual rights and duties of a limited parties are governed by a limited liability partnership agreement, or if there is no such agreement, or there is such an agreement but it doesn't deal with a particular matter, by the first schedule.
So
any reference to a resolution of the partners in relation to a particular matter is reference to resolution passed by all partners unanimously or by such number of them as may be specified in the LLP agreement as the number requires to pass. First schedule.
So the first point is in absence of an LLP partnership, the LLP Act applies. So if you don't have an LLP partnership, LLP Act applies according to this question. Yeah.
So let me ask Malini. So that means if there's nothing written, but the parties are acting in a manner to infer that it's a partnership, the LLP terms would apply. Is that correct? Is that the position?
Repeat the question.
That notwithstanding that the LLP, there's no agreement and it is not registered, that what is looked at from a law perspective is how the parties are carrying themselves. So if they're carrying themselves as partners in a firm, in an LLP, then that is what is going to be inferred by law.
You know, let's ask this way. For you to register an LLP, do you need an LLP partnership?
You need
Is it a must?
or you need to make reference that you're going to be bound by the act, in my view.
Yes, so there are either two things. Is either you have a limited liability partnership, or the act applies, or where the limited liability partnership is not expressed on, is silent or something, the LLP applies, LLP act applies.
But this one they haven't. So sorry, maybe I can't see the question, the whole question. If you could go to the top. Does it say that the LLP is registered?
No,
their chosen vehicle was they have. The chosen vehicle was an LLP pursuant to a short time LLP. So they registered.
Yes. But
that
you see
was their vehicle. But they didn't have a partnership.
Partnership agreements.
So the act applies.
So the act applies. Are we on the same page?
Yes, Madini.
So there is no written LLP agreement. So this question is testing you on your understanding on LLP agreement, and LLP act. Unaona? So if you look at all these things that they are talking about here, where does the controversy start? Put a larger share capital and there is the sole signatory of the firm's account. DEC is the opinion that there is no controversy even being a signatory. DEC is the opinion that the deed of Rebecca being involved in day-to-day decision of the firm, up to including participating in, she's personally liable for her share of the penalty, and now Drake wishes to expel. So there are two controversies here. She wants her to be personally liable for her share. The partnership pays 500,000 and the year pay 500,000. And also she wants to expel. Unaona?
Yes.
So these are the two controversies that the question needs you to address.
Yes.
You start with section 2. Continue.
So with regard to the liability of Rebecca, by the information that we have there, she has the role of the manager. And if you look at clause 27, part 3b, says a manager of a limited partnership shall be personally liable for all penalties imposed on the partnership for any failure to comply with or contravention of those sections unless the manager satisfies the court that the manager should not be liable. So Drake can rely on that to force her to do it. On the second thing, on expelling Rebecca, he will not be able to do that because an LLP requires that there are two parties. So he would have to first seek for another person to take on Rebecca's position and then retain the LLP. They can change partnership. So he can request that Rebecca resigns and then another one comes in immediate, like at the same time.
Mhm.
Yeah. For
Yeah,
it to remain.
look at.
Uh-huh.
So, is this a penalty? This is a penalty. This is a penalty.
Yes.
Penalty, yeah. Penalty, yeah.
Yes.
So section 27(3) applies, ndio?
Yes.
Haya, what about expelling her?
So this is on termination.
Mhm. Or expelling.
Yes, I'm trying to look
Section
for
13.
the clause. Sorry?
Section 13?
Partners to continue to be liable for obligations of partnership before conversion.
No. Section 13. How partners is it to be a member of a?
Am I looking at the wrong section, perhaps?
Section 13.
Yes, how a partner ceases to be a member. So a partner ceases to be a partner by complying with the requirements of the relevant liability in the absence of such an agreement by giving less than 90 days, not less than 90 days notice to the other partners of the intention of the partner to resign. A partner, this is also ceases to on the partner death or dissolution of partnership. So from this, because this will be the action that Drake wants to take, is to dissolve the partnership.
No, he does not need to. He is not dissolving. He wants to expel her.
So if
Does that apply? 13.
13 doesn't apply.
Okay, look at where we are saying first schedule. Remember, start off one, we say that if there is no partnership, you go to the first schedule. Look at first schedule, Rule 11, That is page 20, page 30. Page 30.
Okay.
Schedule, you talk about paragraph when you're talking about paragraph. So paragraph is first schedule to the LLP.
Do I have the right one? Is that 211? 2011 one?
No.
Schedule.
To 2011, This is
schedule. Second
registration
schedule.
as 15. Registration as at 15 September 2023, Konayo. So I can project 15 imeandikwa hivyo. I think I can project.
Did I see the title of the act?
This one.
It's 2020. How do you say
This is the latest.
2026?
Yeah, you see registration. You go to the Kenya Law website and download the latest. Registration as at 15th September 2023.
Sort of not downloading. So I'm in page 30.
A page that you have seen, eh?
No.
First schedule. You can search first schedule.
So let me check first schedule. So I can't see.
You can't see?
Can't see it.
You have downloaded Nini. That's correct.
Yes. The one that I
First,
have is revised edition 2023.
yeah, have you gone to the first schedule?
So I'm on first schedule.
Yeah, first schedule, the number 11, eh?
11. A partner in a leader may not be expelled by a majority of the unless a power to do so has been conferred by an express agreement among the partners.
So that is the answer.
Okay.
Because there is no express agreement, eh? He cannot be expelled.
Expelled.
Then you can combine with the circumstances now. Cease how a person can cease to be a partner. Eh? Where we read, where was that section?
13, was it 13?
Yeah, cease 13. Yeah.
Yeah.
Yeah, you combine with this the only circumstances so that you get your 6 marks. Eh? Yeah, I think someone needs to read this act with a tooth comb. Eh?
Yes, yes.
Yeah, every small details. That is a challenge from this paper. Eh?
Yeah, for commercial transactions, everything is fine tooth.
Yeah. So we have agreed that we are going to do those 2 assignments. Eh?
Was it
I'm going
one?
to
The 2, draft security agreement and then calculate capital gains tax. Yes.
yes, you do. I'm going to send you the paper after this. Eh?
Thank you.
Yeah, so you do. Then we are going to on Wednesday. This is